to yet another illuminating webinar. Amongst us, we have Honorable Mr. Justice Sunil T. Thomas, a judge of the Kerala High Court. And in our continuum of the consultation of these webinars of Pan India, we have amongst the speaker who has an illustrious career, not only as a lawyer first, and then the most fascinating fact which has attracted us is that he has been a part-time lecturer. And we have, during these webinars and otherwise also, experienced that those who have worked as a lecturers, their insights and way of putting across the things on a particular perspective of law is always insightful. And on this surmise, we requested Honorable Mr. Justice Sunil T. Thomas to give the insights. As we all know that of late, we have started introducing the speaker not to that extent that we believe that rather we should more focus on the subject so that time is always a constraint. So yes, let's have the best of the things from the speaker. Except two aspects we will highlight, that he had also officiated as a district judge in the Kerala Judicial Services, which again is what we can say a feather while we discuss about the speaker, and had also been registrar in the Honorable Supreme Court, which only shows volume of his insights on all aspects. Over to you, sir, on the insights.
Thank you, Mr. Vikas. Good afternoon, my dear brothers and sisters. The topic that I am going to discuss today with you is Specific Relief Act, specific performance of contract, with more emphasis on the impact of 2018 amendment. I'll just go through the history of how the concept of Specific Relief Act came to India. The Specific Relief Act was introduced in India for the first time in 1877. Thereafter, in 1963, it underwent, the act was replaced by the Specific Relief Act of 1963. Then came the amendment in the year 2018. This is just the history. And what is meant by specific relief? As you all know, specific relief is considered as an enforcement of a relief in specie. In specie means one person who is a defaulter, who is a party to the contract and who violates the terms of the contract, is made to perform his part, perform the part which he has undertaken to perform in letter and spirit. That's why we call it the specific relief. And that is completely different from the general reliefs which are available under the civil law. Normally, in the case of civil law reliefs, in case of breach of contract, two reliefs are possible. One is specific performance of the contract, and the other one is damages. Strangely, the concept of common law, as followed in England, was giving more emphasis to damages as the main relief and specific relief as an alternate, substitute, discretionary remedy given by the courts. So the thrust was, in case of a breach of a contract, the court normally will give damages as the relief rather than a specific relief. When in 1877, the Specific Relief Act was introduced in India, we almost followed the common law concept. And though we call it the Specific Relief Act, wide discretion was conferred on the courts to decide whether the relief of specific performance should be granted or specific relief should be granted or not. The thrust was mainly on granting damages as the relief. When the 1877 statute was repealed, and in 1963 the Specific Relief Act was introduced, the same concept was followed. That was in force till 2018. So that ultimately what happens is that under the Specific Relief Act, the main relief granted to the party or normally is one of damages or other alternate reliefs, and specific performance is given. Specific performance of the contract is awarded as an alternate discretionary remedy in exceptional cases. That too in the case of both the immobile property as well as movable properties. In India, around 2016, when we had the liberalized economic policy and when the various infrastructure, the public participation was, the Indian markets were open to foreign depository investors. The government, central government felt that the statutes also need to be revamped so as to give more effect to the economic liberalization, so that it will help the industrial growth, it will help the infrastructural development, etc. So a committee was constituted, an expert committee was constituted by the central government in 2016 to study the Specific Relief Act and to suggest the amendments required. They submitted the report in 2018. The main finding of the expert committee was that the Specific Relief Act, as available in India, could not keep pace with the economic development and the liberalization policies that we are adopting in India. So they suggested that the relief should be more specific relief oriented, and the thrust of amendment of the Specific Relief Act should be on specific enforcement of the contract. Then the committee also found that there was huge delay in the determination of the suits. It also found that foreign investors were or other persons, industrialists, were not very happy to invest in India because they were not sure what will be the ultimate fate in case they go to the court and seek a specific performance of a contract. Then the court, that the special committee also suggested that there should be more thrust on constituting special courts and various other factors. That resulted in the introduction of the Specific Relief Act of 2018 that came into force on 1/10/2018. So what I propose to do is that today we will just discuss what are the salient features of specific performance of contracts, Specific Relief Act, that with more emphasis to the impact of 2018 Act, Amendment Act. Chapter 2, Part 2 of the Specific Relief Act deals with specific performance of contracts, specifically sections 9 to 25. I'll be concentrating more on 4 sections. I'll be dealing with other sections, but mainly concentrating on section 10, section 14, section 16, and section 20. These are the 4 important provisions under the Specific Relief Act in relation to specific performance of contracts. Section 10 deals with what are the contracts which can be enforced. Section 14 deals with contracts which cannot be enforced. Section 16 deals with personal bar against enforcement of certain types of contracts, or certain persons are barred from seeking specific performance, specific relief under the Specific Relief Act. Then 20, which deals with the discretionary power. This is the scheme as per the old Act of 1963. Then I will refer to section what was the impact of the amendment on these 4 provisions. As I just mentioned, section 9 to section 25, sections 9 to 25 deal with the specific relief of specific performance of contracts. Section 9 says that in a proceeding under the chapter 2, a person against whom specific performance is sought is entitled to raise all the grounds which he is entitled to in relation to contracts. Or in other words, what are the defenses available to a person under the Contract Act are additionally available in a suit for specific performance of the contracts. You know what are the normal grounds that we adopt in all this. Instead of repeating what are the defenses available, by the mechanism of providing that all the defenses available to the defendant in relation to a contract under the Contract Act will also be applicable to Section 9. It is made very clear, so that the repetition of what are the defenses available to defendant is avoided. Just about Section 9. Then we go to Section 10. Section 10 deals with what are the types of contracts which can be enforced. As I told you, Section 10 gives wide discretion to the courts. Section 10 says that a contract of the courts can grant, courts may, in its discretion, grant specific relief, specific performance of contract in two situations. First situation is that if there is a finding by the court that there exists no standard for assessing the damage caused consequent to the violation or breach of the contract. The second one is that if there is when the compensation will not give adequate relief to the aggrieved person, or in other words, two conditions which are to be satisfied are: one, there is no standard for evaluating the damage cost. Second is that if the contract is, the damage cannot be compensated in terms of money, adequately compensated in terms of money. So what happens if you analyze the section? You will find that section says the court may, in its discretion, grant relief when there exists no standard for evaluating the damage cost. That means even if the court arrives at a finding that there was a contract was validly entered into, the defendant did not comply with the terms of the contract, still the court can exercise the discretion and instead of ordering specific relief, can give the alternate relief only if, can order specific performance only if no standard exists for evaluating the damages. If there was a standard available for evaluating the damages, court could have exercised the discretion in favor of damage compensation. The second option, second situation is under Section 10 is when compensation, even if the court arrives at a conclusion that the compensation can be granted, but compensation will not satisfy adequately the damage cost. So that only if these situations exist, then the court will order specific performance. That too within the discretion of the court. There are two presumptions under Section 10. The first presumption is that in case of contract relating to immovable property, in the absence of any material, it will prima facie be presumed that damage cannot be compensated in terms of money. Whereas the second presumption is that in case of movable properties, damage if caused can be compensated in terms of money, unless the article involved is a matter of special interest to the parties. Say, for example, a painting, very valuable painting. It cannot be assessed in terms of money, though a movable item. or it may be an item on which is not normally available in the market, or it cannot be made available. It's not a matter of commerce. So when we analyze section 10 as such, what we find is that the courts are conferred with wide discretion. Even if the court finds that there is a breach of contract by the defendant, still the court can grant the alternate relief of compensation, damages. Only if it is not possible, then the court will think of granting specific relief. This was the wide discretion enjoyed by the civil courts in India under section 10. Now, section 10 has to be read along with section 20 of the original act, which deals with discretion. Section 20 says that though the power of the court or the jurisdiction of the court to grant specific relief is discretionary, it should not be arbitrary. The courts are not expected to grant relief merely because it finds that it is lawful to grant the relief. Then the order granting specific relief should be based on sound and legal principles and on the basis of judicial principles and liable to be corrected by the appellate court. Or in other words, though the section 10 confers wide discretion on the court, that is circumscribed, that is limited by certain restrictions, that it should be based on sound legal principles, and it should give reasons as to why it is thought of exercising the discretion. That's why the statute says, section 20 says, it shall be liable for correction by the appellate court. Only when that will be possible only when it is reasons are given. So this is the scope of section 10 and section 20. Now I'll tell you what is the impact of 2018 amendment. By 2018 amendment, both the clauses under section 10 were abandoned. The discretion conferred in the body of the statute was also given away. And virtually under the new section 10, court is given the absolute freedom, or it has become not a discretionary remedy, but it is almost virtually, I will say that it is mandatory for the courts to grant decree if the facts are in favor of the plaintiff. Now section 10 says that the court shall grant specific relief subject to three provisions: section 11(2), section 14, and section 16. This is the amendment made under, these are the only restrictions in relation to the power of court in granting a decree of specific performance. The court can grant, section 10 says, the present section 10 after 2018 amendment reads that the courts can grant specific relief subject to section 11(2), section 14, and section 16. Then corresponding amendment was brought in section 20. The limits of discretion mentioned in section 20 was completely revamped, and a new section was introduced, which is a very important concept brought under the Specific Relief Act. That is known as substituted performance, which was not a relief available under the 1963 Act. What is meant by substituted performance? Apart from the relief of damage, apart from specific enforcement of the contract, A third option is available to the aggrieved person in case of a breach of a contract by exercising the right of substituted performance under Section 20 of the Specific Relief Act. I'll tell you how the Section 20 works. If there is a breach of contract, the aggrieved person is entitled to require the defaulter by giving him 30 days notice to perform his part of the contract and inform him that in case of breach, I will get it done at my expense, through my people, through my employees, or through another agency. So after giving 30 days notice to the defaulter, the aggrieved person is entitled to get the contract performed, either engaging his own employees or engaging a third party, a service provider. Apart from this, he is also entitled to seek the cost, damages, and the expenses incurred in substituted performance. So this is a very innovative concept brought under the 2018 amendment. So that is section 40, section 10 and section 20. I think this much it is clear. So the basic change that has come in is that it is no longer a discretionary relief, and the rule and the situation now, which was originally specific performance being the exception and damages being the rule. Now the situation is that specific performance is the rule and granting of damage is an exception. So this is section 10 and section 20. Now we will come to section 16, which section 14, which I referred to at the beginning. Section 14 says that section 14 refers to 4 types of contracts which cannot be specifically enforced. One is a contract. Section 14 says the first clause is that when the compensation in terms of money is the adequate relief, such contracts cannot be enforced. So that is the first exception. If the contract is such that it can be payment of compensation will form the adequate relief, then such contracts cannot be enforced under section 14. The next type of contract which cannot be enforced are the contracts which runs into minute and numerous details, or dependent on the personal qualification or volition of the parties to the agreement. If the contract is such that it involves a very minute, numerous things to be done. Say, for example, the contract for installation of a very complicated machinery parts, assembling of the machinery parts. Because that there may be a lot of specifications involved. Or such type of contracts cannot be specifically enforced. Or there may be a contract which depends on the personal qualification or volition of parties. One example may be when a person is engaged by the plaintiff to paint a picture. It depends on the qualification and the experience and the expertise of that painter. That's not something which can be specifically enforced. Or a contract to design a particular machinery. That depends on the personal skill of the architect or the designer. So that's not a contract which can be specifically enforced because that consists of the personal skill of the person or the volition of the person. So such contracts cannot be specifically enforced. The third category of contracts which cannot be enforced are one which involves by very nature of it, it is determinable, which can be terminated. Say, for example, a contract to be performed for a limited period, contract to let out a building, an agreement to let out a building. Maybe these are the examples. When the contract by itself is determinable at the option of one of the parties, then it cannot be specifically enforced. The fourth category is the contracts which involve continuous performance, which cannot be supervised by a court of law. That is a lengthy procedure, several steps to be taken. It involves a continuous performance of several acts. And if the court grants a decree of specific performance, it will be impossible for the court to supervise the execution of that decree. Because what is the principle involved in that? The principle is that the court is not expected to keep away all its work and go for execution of a decree which involves a continuous process. I will give an example with reference to a decision of the Supreme Court. I will give the citation and the name of the case. Those who are interested may please take down. That is Her Highness Maharani Shanti Devi Gaikwad. Her Highness Maharani Shanti Devi Gaikwad versus S.H. Patel. Her Highness Maharani Shanti Devi Gaikwad versus S.H. Patel. The citation is 2001 5 SCC 1010 1010 2001 5 SCC 1010. That was a contract by which an agreement was entered into for construction of several buildings for several houses for the landless poor people. There was a breach of contract. Matter went up to was taken to the court. It came ultimately to the Supreme Court. Then the Supreme Court took the view that it involves a continuous performance because there are definite plans for the construction of the buildings. It has to be, it runs over a long period. It involves several complicated things, so that it is not a matter which the court can grant a decree and supervise execution. So the court said that it will come under the fourth clause of section 14 and it cannot be specifically enforced. So these are the four categories of contracts which cannot be enforced, which are exempted from seeking relief under section 14 of the Specific Relief Act. This has also been undergone amendment. But it is not a very elaborate amendment. I will tell you that the amendment was basically in relation to the first clause. When compensation can be, when the damage can be adequately compensated by in terms of money, which is the first clause, which category exempted under section 14, has become redundant after 2018 amendment, because the question of an alternate relief of damage is no longer available. That is not the rule now. So what the amendment was that in case of clause 1, the clause now available is that if the contract, a person who has obtained substituted performance of contract under section 20 is not, and such contracts cannot be enforced. The reason is very simple. When the plaintiff or the aggrieved person gets a right to invoke section 20 and get the contract specifically enforced by substituted performance, he cannot ask again for a specific performance of the agreement which stands performed. The only thing that he can do is, only further relief that he can ask, apart from the specific relief, apart from the substituted performance, is to ask for cost, expenses, and damages if any cost. These are the three things which he can, ancillary reliefs which a person can ask in addition to the specific performance of the agreement. Now, other conditions remain almost same, except in one clause. There is a minor amendment, that the second clause, which says that it depends on that regarding the personal volition. The first part of the clause, which says that numerous and minute details that has been abandoned, has been deleted. So this is the, all other sections remain almost, subsections remain the same. So this is the impact of 2018 amendment on section 14. Now we will refer to section 16. Section 16 is the bar under the specific relief act in relation to certain types of contracts. Or under section 17, three categories of persons are barred from seeking specific performance. The first one is those persons who are not entitled to get damage. If a person is not entitled to get damage as an alternate relief, he is not entitled to seek the specific performance of the agreement also. In other words, if the aggrieved person is not entitled to get damage as an alternate relief, he will not be entitled to seek specific performance also. That's the one personal bar, the first personal bar under section 16. I'll give you an example. Suppose one person offers to sell an item of property over which he has no alienable interest. Naturally, that cannot be enforced. Since he has no right to the property, he cannot ask for specific performance of that agreement. Since he cannot ask for the specific performance, he is not entitled to get damages also. Since he is not entitled to get damage, conversely, he is not entitled to ask for specific performance also. This is the impact of that. The second one, the second category of persons who are personally barred from seeking relief are those persons who have become incapable of performing the contract, or if he has violated the essential terms of the contract. So that if the second category is persons who have become incapable of performing his part of the contract, then he cannot ask for specific performance by the other person. I'll give you a typical example. A person becomes insane after entering into an agreement. Certain things are to be done personally by that person. Naturally, if he becomes incapable of performance of his part, necessarily he cannot ask for a relief under section 16. Or he cannot seek relief under the Specific Relief Act because of the bar under section 16. The third category of persons who are disentitled from claiming relief under section 16 or claim specific relief is those persons who failed to ever plead, ever and prove that he has performed his part of the contract, or that he has been ready and willing to perform his part of the contract, and he has always been ready and willing to perform his part of the contract. That's a concept which we always call as readiness and willingness. So the third requirement is that a person who fails to plead, not only plead, and he should prove also before the court that he was ready and willing to perform his part of the contract, or he has performed his part of the contract. That is, these are the three categories of persons who are exempted from, who are barred from seeking a proof of supervision under Section 16. Now, this Section 16 has got two explanations. One explanation is that a person who is bound to make some payment as a part of the contract, as a part of the agreement, is not bound to pay the money to show his bona fides or to deposit the money to show his bona fides. That means if the buyer is bound to pay the balance purchase price and he asks for a specific, he files a suit for specific performance to show his bona fides, he need not deposit the money in court to show that I got the capacity, I got the financial capacity. Or in other words, plaintiff is not entitled to jingle the coins before the court to show his bona fides. But he has to establish before the court that he has the capacity to raise the money. So the explanation to Section 16 provides that the plaintiff or the person claiming the right who is bound to make payment under the Act is not expected to deposit the money before the court or to pay or tender the money to the opposite side. The second one is that, the second clarification or explanation is that it is a duty of the plaintiff to plead that he has performed or is ready and willing to perform his part of the contract. Now, you must have come across umpteen number of decisions of the Supreme Court in relation to readiness and willingness, jingling the coins, to jingle the coins before the court to show the bona fides. When should, how long a person should be, how long the person, a person should continue to remain ready and willing. Is there some problem, Mr. Vikas? Is there a problem with the breaking of the sound? Mr. Vikas?
For a fraction of around 2-3 minutes, there was a low bandwidth at your side. Now it's okay.
No problem. It's okay now.
Yes. For a few minutes, it was displaying on the your screen that there is some low bandwidth, but now it's fine.
Okay. Thank you. Because somebody has posted that.
Oh,
okay, thank you.
That shows that you are speaking with so much fluency, yet you are seeing what is being posted on the chat box.
Now, what is the impact of the amendment, 2018 amendment on Section 16? Section 16, the first clause has undergone a change. The first clause which says that a person who is not entitled to get compensation is not entitled to get the specific performance. That clause has been deleted now by way of 2018 amendment. It is now substituted by a provision in relation to the substituted performance. The first, under the 2018 section 16 first clause says that a person who has obtained substituted performance is barred from seeking specific performance of the agreement. The same reason which I said. Then the second exception remains the same. A person who has become incapable of performance is not entitled to get relief. He is not barred from seeking relief under the Specific Relief Act. The third clause regarding pleading and proving of readiness and willingness, there is a minor change. The change is that it is no longer required to plead that the person has done, the plaintiff has done his part of the contract, or that he is ready and willing to perform his part. Or in other words, after the 2018 amendment, the pleading need not be there, but he should prove his readiness and willingness. What is the justification? Can there be a proof regarding a proof without a pleading? Even the earlier amendment earlier statutes, 1963 amendment insisted that there should be a pleading regarding readiness and willingness, and he should prove that also. Now the position is that he need only prove it, though there did not be a pleading. What is the rationale behind such an amendment? Probably the only reason is that maybe that there used to be indiscriminate dismissal of suits on the ground that readiness and willingness have not been exactly pleaded in letter and spirit, or same words of readiness and willingness have not been reproduced in the statute. Probably that must have prompted the Parliament to delete the term plead. But one person need only prove that. Then the other explanations regarding depositing the money for the court remains the same. That plaintiff should prove the performance, etc. The same remain. So very substantial changes have not been introduced in section 16. But when you go through section 14 and section 16, you will find two things. Substituted performance is given more emphasis in section 14 and section 16, reiterating the fact that the discretion has been completely removed and it has become a specific performance of the contract is no longer discretionary, but a right which he is entitled to. Almost a right, I may say, subject to the fact that the plaintiff should prove that there was an agreement, it was voluntarily entered into, all the ingredients under the agreements are there, Contract Act are also there, and there is a violation or breach of the terms of the contract. For your reference, I will just refer to some of the decisions regarding readiness and willingness, regarding the pleading and proving, and how far this readiness and willingness should be there, how long it should be there. The first decision is regarding the continuous readiness and willingness. That I will give you the citation. Those who are interested, please take down. NP Thirugnanam, NP Thiru, THIRU, GNAMAN. We pronounce it as Thirugnanam. THIRUGNAMAN. Thirugnanam, represented by his LRs, versus Dr. Jagan Mohan Rao. Jagan Mohan Rao, it says that, I will give you the citation, 1995, 5 SEC, page 115, 1995, 5 SEC, page 115. That Supreme Court said that it is obligatory on the part of the plaintiff to plead and establish that he was ready and willing, and that his readiness commenced from the date when he entered into the agreement, and that continued till the date of decree and thereafter. Or continuous readiness and willingness has to be established by the plaintiff to get the benefit of specific relief or specific performance. The one latest decision on this point is a 2020 decision of the Supreme Court. It is C.S. Venkatesh. C.S. Venkatesh versus A.S.C. Murthy. A.S.C. Murthy, M-U-R-T-H-Y, Murthy. 2020, 3 SCC 280. 2020, 3 SCC 280. That decision also deals with the various facets of the concept of readiness and willingness. What is meant by readiness? What is meant by willingness? To what extent the plaintiff should establish that? Regarding the pleading and proving, the decision is Kalavadi versus Rakesh Kumar. Kalavadi, K-A-L-A-V-A-T-I. Kalavadi versus Rakesh Kumar. AR 2018 SC 960. AR 2018 SC 960. That also refers to the pleading and proving. Then the next decision is on a slightly different point. Vijay Bharati versus Vijaya, V-I-J-A-Y-A, Vijaya Bharati versus Savitri, S-A-V-I-T-R-I, Savitri, 2018, 11 SCC 761. The question involved that in that case was whether an assignee from the defendant is entitled to set up the plea that the plaintiff was not ready and willing to perform his part of the contract. That was a case wherein, after entering into an agreement for sale, the defendant sold his property to a third party. Suit was filed. The question came up whether the third party the purchaser is entitled to set up the plea that the plaintiff was not ready and willing to perform his part of the contract. Supreme Court said that the purchaser is also entitled to set up the plea of readiness and willingness, or that the plaintiff was not ready and willing to perform his part of the contract. Now, I have been repeatedly telling you about the readiness and willingness. Now, the question that will come up is, suppose the plaintiff fails to plead specifically the words, he was ready and willing to perform his part of the contract, what will be the impact of that? Can a suit be dismissed on the mere ground that the plaintiff has not pleaded specifically or used the word readiness and willingness? What should be done? There are two Supreme Court decisions on this point. Their decisions are Syed, S-Y-E-D, Syed Dastagir, D-A-S-T-A-G-I-R, Syed Dastagir versus T.R. Gopalakrishna, T.R. Gopalakrishna, 1999, 6 SCC 337. (1999) 6 SCC 337. The second decision is Vishwanath Ghosh, Vishwanath, B-I-S-W-A-N-A-T-H, Vishwanath Ghosh versus Govinda Ghosh, Govinda, G-O-B-I-N-D-A, Ghosh, G-O-S-H, 2014, 1 SCC 605. In both the decisions, the Supreme Court held that exact reproduction of the words plaintiff was ready and willing, or that he was ever ready and willing to perform his part of the contract, need not be reproduced. Or in other words, suit cannot be dismissed or shall not be dismissed on the ground that exact words of readiness and willingness have not been pleaded. But in sum and substance, the readiness and willingness have been made out, explained. Parties understood about the readiness and willingness and went for trial. Then the suit cannot be dismissed on the mere ground that the words readiness and willingness have not been specifically pleaded. It is not that technically required. That's the ultimate conclusion that the Supreme Court arrived at. But that does not give away, abandon the right to, duty to plead and prove. That's the decision. Then there is one decision more. That is Kamal Kumar versus Premalada Joshi. Kamal Kumar versus Premalada Joshi. AR 2019 SC 459. That was a case wherein the Supreme Court laid down the parameters for determining or laid down the guidelines for granting specific performance. What the Supreme Court said was that on the basis of evidence, the court should first find out whether there was a concluded contract. 2, whether the contract was parties were ready and willing to perform their part of the contract. 3, whether the plaintiff was the third was whether there was the plaintiff has performed his part of the contract and to what extent. Fourthly, whether the relief of specific performance is to be granted. Fifthly, whether any alternate relief other than can be granted. These are the guidelines laid down by just for that purpose. Same principles which the Supreme Court has referred to earlier. laid down earlier has been paraphrased. That's the significance of that decision. That's why I referred to that. Now we come to section 20. Section 20, I gave an introduction to that. What is section 20? I said that that's the most innovative provision under the Amended Act 2018 Specific Relief Act. A new relief is granted. I'll just repeat it and say that the specific substituted performance means in case of breach of a contract, the aggrieved person is entitled to call upon the other side by giving 30 days notice in writing, requiring him to perform his part of the contract and informing him that if it's not done, I will get it done, engaging the services of my employees or a service provider. If that is done, the consequence will be that he shall do his he shall get it done and recover damages if he has sustained any damages, cost and the expense incurred for substituted performance. Now what will happen is that since this new regime of wide provisions have come, in future what is going to happen is that whenever the contracts are entered into, parties will also carefully include one clause as to how substituted performance should be enforced, because that may result in a lot of difficulties. Because suppose the notice for substituted performance is given and the plaintiff, or not the plaintiff, the aggrieved person gets the work done utilizing the most expensive builder or a person who service provider, that is at the risk of the other person, or he does something more than what is contemplated, something ancillary to the agreement or something more. These are the difficulties that may practical difficulties that may arise. So naturally, when new contracts are entered into, you have to, suppose you are asked to draft a document, draft a contract, you should be careful about what are the consequences that may follow in case of breach of contract by one party and the modalities of enforcing substituted performance. Otherwise, the person who commits breach will have to pay through his nose. So these are the crux of the 4 important provisions which I referred to. But incidentally, I referred to section 9 also. Now, I've been telling that, I repeatedly told you that the original act of 1963 conferred on courts wide discretion. So while bolding the relief, the court had the duty to take into consideration the principles of equity also. And repeatedly the courts have held, Supreme Court has also held that the equitable principles can be taken note of by the court and refuse the specific performance if the party has not approached the court with clean hands. If the plaintiff is guilty of laches, delay, improper performance, misconduct, though that may be those may be reasons for denying him the relief. And the equity principles have been dealt with by the Supreme Court in 3-4 decisions, which I will refer to. The first decision is A. Kanthimani, Kanthimani, Kanthimani versus Nasru Ahmad, Nasru Ahmad. 2017 4 SCC 654. 2017 4 SCC 654. It deals with the principle that a person who seeks equity should do equity, or a person who is not equitable is not entitled to get a relief, and is a relief which is otherwise entitled can be denied on that ground alone. Then the other decision coming under section 20 is Jaya Kanthan, Jaya, Jaya Kanthan, Kanthan, Jaya Kanthan versus Abhay Kumar, Abhay Kumar, ABAY, Abhay Kumar, 2017, 5 Supreme Court cases, 176. In that also the discretion and the equity principles were explained in detail by the Supreme Court. The third decision is Yusuf Khan, Yusuf, YOUSEF, Yusuf Khan versus Prajida Developers, Prajida, PRAJIDA, Prajida Developers, 2018, 12 SCC, page 683. That was a case wherein one person received a huge amount of 8.5 crores. 8.5 crores for construction of a building. He did not do anything for a long time. When the matter came, all the courts consistently held that he did not do equity and he is not entitled to get the relief. And he was directed to return the advance money with huge penalty. Definitely, the conduct of the party assumes significance when a discretionary power is going. You know that. One situation came up before the Supreme Court in another decision. That is the latest decision of 2020. Atma Ram, ATMA, Atma Ram versus Charanjit Singh, CHARANJIT, Charanjit Singh, 2020, 3 SCC, 311. In that case, what happened was that the plaintiff issued a lawyer notice in the year 1996, calling upon the defendant to perform his part of the contract. Then he remained silent for 3 years. In 1999, he filed a suit. The suit was not one for specific performance. He filed a suit for mandatory injunction. Later, the suit was amended with the permission of the court. Necessary court fee was also paid and converted into a suit for specific performance. When the matter came up before the Supreme Court said the very fact that he waited for 3 years after issuing the lawyer notice, and even after 3 years, he did not file a suit for a special performance. He filed a suit for mandatory injunction, which was converted into a suit for specific performance, indicates that he was guilty of misconduct. His conduct was not appreciable. The Supreme Court held it as a ground for refusing him relief. So these are the various grounds, various parameters or various facets of the concept of readiness and willingness, equity principles, etc. Now, gradually, in the course of time, other practical difficulties also come up. So the Supreme Court also adopted new innovative principles to tackle the new situations. Or in other words, since the nature of litigation in relation to specific performance has changed, the courts had to devolve new equity principles or new yardsticks to handle peculiar instances. I'll give you one typical example. That was a case in Nirmala Anand. Nirmala Anand versus Advent Corporation. Advent, E-A-D-V-E-N-T. Advent Corporation, 2002 SCC 146. Nirmala Anand versus Advent Corporation, 2002 8 SCC 146. That was a very peculiar situation came up before the Supreme Court. What happened was that Nirmala Anand agreed to purchase a flat from the builder in the year 1966 for a total consideration of 60,000 rupees. Then litigations arose. Builder did not give the handover possession. She filed a suit. Various contentions were set up. The matter came up before the trial court. Trial court found that Bombay has changed a lot in the meanwhile. The value of the flat has gone up. So the suit, if it is decreed for 60,000 rupees, that will cause injustice. So dismiss the suit. When the matter was taken to the Supreme Court, to the High Court also agreed with that. So with the concurrent findings, this lady came up to the Supreme Court. Matter was taken up for hearing in the year 2002. Long 36 years after the institution of the suit before the trial court. Supreme Court also found that by that time Bombay has completely changed. The value of flats have gone up considerably. And if we ask plaintiff grant a decree of specific performance, that will be doing violence to principles of justice. But at the same time, Supreme Court also said that there was nothing to show that she was at default. So merely because there was an inflation value of the prices, can she be denied the right to get a specific performance? But at the same time, Supreme Court also felt that the equity principle did not permit handing over possession or a specific performance at the rate entered into 36 years back. So ultimately, Supreme Court found out a new yardstick and said that, okay, we are going to decree the suit, grant a specific performance, subject to the condition that Nirmala Anand should pay a further sum of rupees 6,25,000 over and above the agreed amount, so that equity was balanced. Because the Supreme Court said that if we grant a decree, the plaintiff alone will be benefited. Some benefit should go to the builder also. That's how it was decided. What happened was that decision in 2002, Nirmala Anand was followed by Supreme Court in two subsequent decisions in 2015. Those two decisions are K. Prakash versus B.R. Sampath Kumar. K. Prakash versus B.R. Sampath Kumar, 2015 1 SCC 597. K. Prakash versus B.R. Sampath Kumar, 2015 1 SCC 597. The next decision is Serena Siddiqui versus A. Ramalingam, 2015 1 SCC 705. Serena Siddiqui versus A. Ramalingam, 2015 1 SCC 705. In both these decisions, the Supreme Court followed the decision in Nirmala Anand's case by apportioning the benefits. Now, one more peculiar decision of the Supreme Court is there that I will refer to that and we'll go to the next topic. That is also the concept of balancing of equities. A peculiar situation came up before the Supreme Court in SYSCON consultation, SYSCON, SYSCON, SYSCON Consultation Private Limited versus Primella Sanitary Products, Primella, Primella, Primella Sanitary Products, 2016, 10 SCC, page 35. That was a case in which the joint owners of an item of property entered into an agreement for sale, agreement of sale of that property. But at the time of trial, it was found that one of the co-owner had not in fact agreed for sale. Because the situation was that agreement for sale was entered into by one of the co-owners, one of the joint owners, as the power of attorney holder of all other persons. At the time of execution of the agreement, one of the co-owner had, one of the joint owner had withdrawn his power of attorney, but others agreed. So Supreme Court, the trial court found that all the joint owners have not agreed for sale of the property, but all except one, or except one, all have agreed. When the matter came up before the Supreme Court said, okay, we will balance the equities and direct the joint owners who are willing to perform their part to give their share. So naturally, they will get the plaintiff will get a decree for that portion, except the one person who was not willing. Then he can ask for partition of the property and separate possession. That's the principle. So we cover the topic of section 10, 14, 16, and 20. We'll just refer to one more principle. That is the time essence of the contract of sale. We normally say that time is not the essence of the contract, especially in the case of immovable properties, contract of immovable properties. Time is not the essence of the contract. That is a principle that we normally follow. This came up before the Constitutional Bench of the Supreme Court in Chandrani versus Kamal Rani. Chandrani, CHAND, Chandrani versus Kamal Rani, Kamal, KAMAL, Kamal Rani, 1993, 1 SCC 519. 1993, 1 SCC 519. That's a constitution bench decision. In that, what the Supreme Court held was that there is no presumption that time shall be the essence of the contract. However, whether time was the essence of the contract is a fact that can be discerned from the nature of contract, property sold to be assigned, attendant circumstances, and the intention of the parties. And this concept remained the same for a long period. When the same issue came up before the Supreme Court in another case, that is K.S. Vidyanathan, K.S. Vidyanathan, Vidyanadam, Vidyanathan, and others, versus Vairavan, 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 1997, 3 SEC 1, page 1. In that, Supreme Court approved that actually it has to approve not a larger bench, approved the or followed the constitution bench decision, but said that the concept that time was not the essence of the contract in relation to immovable properties was developed in England at a time when the price of the property remained static and there was no inflation. But since the time has now changed, value of the properties have gone up, inflation is there, so it is high time that we have a relook at the principle of time is not the essence of the contract. Supreme Court was of the view that now the value of the properties are increasing, so that we need to have a relook of that principle. This view was affirmed by Justice R.V. Ravindran in the subsequent decision in Sharadamani, Saradamani, Sharadamani Kandappan, Kandappan, Sharadamani Kandappan versus S. Rajalakshmi and others. 2011, 12 SEC, page 18. Now, the question that you have to keep in mind is that the principle of equity principles, discretionary relief, how far that will survive after the 2018 amendment. Definitely, in relation to the statutes, in relation to decisions which have already been decided under the old act, these principles are relevant. That's something which you have to think about. So I have given you the main amendments or amendments in relation to the main statutes. Then I will just briefly refer to what are the other amendments brought in relation to specific performance of contract. The most important is under section 14A of the Specific Relief Act. 14A is a new provision which empowers the court to appoint experts. I just mentioned earlier that the concept or the nature of contracts have undergone tremendous change now. Various complicated contracts are coming up. So naturally, the courts should also be equipped to decide, adjudicate new types of contracts, specifically in relation to infrastructure contracts. A contract with a specific performance may involve accounting. It may involve scientific matters. It may require some assistance of the engineers. So to give sufficient input for the purpose of adjudication of complicated matters under section 14A of the amended act, courts are empowered to appoint experts in the concerned relevant field. If the matter relates to accounting, a chartered accountant. If matter relates to engineering, an engineer. It relates to designing of a building, architect. So such experts, help of experts can be gathered by the court, and their evidence will form part of the record. And if anybody wants to challenge that, the expert can be called upon to depose in terms of, to give evidence in terms of his report. So that is one amendment, new amendment brought in, new provision brought in under section 14A, which was not there earlier. Then there are three other new sections. One is section 20A. The next one is 20B and section 20C. I told you earlier that a lot of infrastructural developments are coming in India. Parliament also felt that in relation to the new infrastructure projects, there should be specific provision to take care or to ensure that such projects are not delayed or hampered or interfered due to judicial proceedings. You will find that the certain projects are brought under Schedule 1 of the Specific Relief Act, like buildings, construction area, construction of dam, irrigation, canal, power projects. These are categorized under Schedule 1 and called as infrastructural projects. Section 20A says that the new provision, which was introduced in 2018, provides that in relation to infrastructural projects, a contract relating to infrastructural projects, no civil court shall grant an injunction which will have the effect of hampering the project. So there is a bar in relation to granting of interim injunctions in relation to infrastructural projects. Otherwise, you know what may happen. A company investing huge amount for infrastructural project, then somebody can raise an issue, gets an order of injunction that will stall the entire project. So that is sought to be avoided by the introduction of section 20A. Section 20B, capital B contemplates constitution of special courts for adjudication of disputes relating to infrastructural projects. That is confined to infrastructural projects only, not in relation to every statute and every suit under a Specific Relief Act. It authorizes the state government in consultation with the state high court to constitute such a number of special courts which will deal with suits relating to infrastructure projects. Then the third aspect is, new provision introduced by the 2018 amendment is section 20C, which imposes a time limit for the adjudication of suits. Section 20C says that every suit under the specific relief act in relation to specific performance of contracts shall be adjudicated and completed by that court within 12 months from the date of service of notice on the defendant. Court is authorized to extend it further up to a maximum of 6 more months, subject to the condition that the court should record the reasons why it is being extended. So we almost now, these are the important provisions, amended provisions. We come to almost the last topic, except now one more topic remains. I will conclude after that. That's the most important topic. The question is 2018 Act retrospective or not? Or in other words, will 2018 Amendment Act apply to litigations that were commenced under the 2018, under the old Act? That's a point which has not been finally adjudicated and decided. What you will find is that in the 2018 Amendment Act, there is no saving clause. There is no transitional provision which says that the litigations initiated under the old Act will not be affected by the amendment. Now we know how far it is, how far we go by the concept of prospective effect or retrospective operation. Normally, one of the tests applied is to decide whether the statute is procedural or substantive one. If we analyze the scope of amendment, the main thing that we find is that discretion has almost been completely taken away. It has become a substantive right of the parties, the plaintiff, to get a decree, if in appropriate cases, definitely. The defenses that were available to the defendant, say for example, by saying that, okay, there is a breach, but still he can be compensated in terms of money, specific relief should not be granted. There is no standard available for evaluating the damages, or that the damage caused to the plaintiff can be compensated in terms of money. These two defenses have been taken away. And a very valuable right is conferred on the plaintiff to claim a substantive enforcement of right under the Specific Relief Act. Then new provisions are also there. Cumulatively, whether the new act will have an effect of retrospective operation. As I told you, there is no direct decision on this point, but there are few decisions which lay down the principle that Specific Relief Act is a procedural law. I'll tell you, give you the citations. The two decisions in relation to the 1877 Act are the two High Court decisions. One is Maulavi Ali Hussain, Maulavi, M-O-U-L-V-I, Maulavi Ali Hussain, H-O-S-S-A-I-N, versus Rajkumar Haldar, Rajkumar Haldar. AR 1943, Calcutta 417. Then the other decision is Hanumantarao Deshmukh, Hanumantarao Deshmukh versus Krishna Bai, 1986, 1 Bombay, CR, page 50. In these two decisions, the question whether 1987 Act was retrospective in operation. Certain amendments brought to the 1877 Act were retrospective in nature, was considered. In both the high courts took the view that specific relief is a provision relating to. You want the decision to be cited once again? First one is AR 1943 Calcutta 417. AR 1943 Calcutta 417. And the second decision is 1986 1 Bombay CR, page 50. The court said that both the high courts held the view that Specific Relief Act is defined as a procedure for enforcement of rights. So they took the view that it is a procedural law. If we go by that principle, procedural law, then it can be retrospective. So both the decisions were confined to the aspect whether it was procedural or not. Then the 1963 Act, certain amendments brought introduced in 1963 Act was considered by another High Court, Calcutta High Court, in Radheshyam, RADHESYAM, Radheshyam Kamila, 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 versus Kiran Bala, KIRAN, Kiran Bala, AR 1971 Calcutta 341. AR 1971 Calcutta 341. In that case also, the Calcutta High Court took the view that Specific Relief Act is essentially a procedural law. Then there is a Supreme Court decision. That is Adhunik Steels Limited, ADHUNIK, Adhunik Steels Limited versus Orissa Manganese and Minerals Private Limited. Orissa Manganese and Minerals Private Limited. Adhunik Steels Limited versus Orissa Manganese and Minerals Private Limited. 2007 SEC, page 125. In that case also, Supreme Court, in a different context, not regarding the retrospective operation or not, in a different context, held the view that Specific Relief Act is a procedure. Is a procedural law. Supreme Court said that it is a procedural law. Now, with this background, in this background, we have to consider whether Act is retrospective or not. But one view is that, though we call it a procedural law, there are certain substantive rights involved. Right is, by amending the statute, certain rights, substantive rights were conferred on the parties to claim relief as a matter of right. At the same time, several defenses which were available to the defendants were taken away. Can you say that it is still procedural? This is a question that you have to find out the answer. Till the matter is finally decided by the Supreme Court. So we come to the end of this session. And now I think it is now it can be open for discussion.
Yes, sir. We'll ask. Though few questions
Yes.
have come so far.
Ah,
We will see. We will request the participants to pose the question.
yes.
This is by in view of the judge, in view of the decision of the Supreme Court in Indus Bank case, is not the effect of the amendment retroactive. He's saying
That's personally, if you ask me whether it is retrospective or not, my personal view. I do not know whether what will be the on base of what I may take this judicial decision, but personally I feel that it should not be retrospective. It should not be. Because various defenses have been set up already. Plaintiff must have, defendant must have taken up the plea of readiness and willingness. He must have taken up the view that it is not something which can be compensated in terms of money. So that everything goes now. So I do not know what will be the view of the Supreme Court on that or other high courts. But the Supreme Court decision in Adhunik Steels was not based on the retrospective aspect, but it was purely on the ground that, purely on the basis that the opening, the statute begins by saying that a statute for enforcing certain rights. Thereby, it was interpreted as a procedure law. That's it. Yes.
Srinivas asks, kindly elaborate the practical problems which may arise because of the alternate remedy given under Section 20.
20, the problem will be that contract is to be, there are certain obligations on plaintiff and defendant, both sides. The plaintiff alleges that defendant has not done that work. Probably there may be some default on the side of the plaintiff also, which must have triggered a dispute. You give a plaintiff sends a letter to the defendant, and defendant says, I was not able to do that because of you did not give me the property for earthwork or construction of the building. Possession of the property was given later. On that in that background, suppose the plaintiff waits for 30 days and goes for specific enforcement substituted performance. That may cause prejudice to the defendant. Secondly, say construction of a building, I'll make it a typical example. Construction of a building, the defendant must have accepted the contract, visualizing the overheads which he can reduce so that he can profitably construct the building. He responds by saying that, or he does not reply. Then the plaintiff gets it done through an architect who is very expensive, using and a contractor who use all ultra modern machines, and the bill comes to several lakhs of rupees, much higher than the original one. Will not a situation arise wherein he gets the work done through another person and very heavy cost is imposed on the defendant? That may work out in justice. So these are the practical difficulties that will come. Definitely, it is a relief. It is a new relief given to the parties. But practical aspects like this may arise. Or there are certain expense which the normal contractor would have been able to reduce. The plaintiff is not bothered about how he makes profit. So that's the problem. Yes. Anything else?
So this is by two persons have asked. Does Section 6 does not bar a person from instituting a suit to establish his title to immovable property and to recover the possession of the same?
Yes, because now along with once he fails to ask for compensation, if there is a suit for specific performance is instituted, he has got other leaves. He can ask for other leaves. One, he can ask for damages if he has sustained any damage. He can ask for compensation. He can ask for possession. He can ask for partition and possession of the property. These are the various reliefs which can be raised. But if a person who is entitled to seek damages fails to ask for that, he will be disentitled from seeking the same claim in the light of Section 21 of the Act. Yes. Then he can ask for refund of the advance money. That's why the provision says that the court can permit amendments to be made in the plaint if he has not asked for that. That much liberally is there. Once he has abandoned that right, he cannot go for a separate suit. Clear? Yes. Which one is the next?
This is this is Payal Bharat Kotwani. If a developer does not undertake redevelopment for 7 years and the building is in a dilapidated condition, no time given in the contract, how can the tenants be protected?
And can you just repeat it?
Yes, sir. This is by Advocate Payal Bharat.
There is something, it's not clear, Mr. Vikas. That's not audible. It's not audible, Mr. Vikas.
I will ask Payal to repost the question. Somehow there was an internet problem on my side.
Yes, yes.
And the other persons can also post the questions again.
Yes.
2-3 people have done. One was, yes, this is by Payal. Subodh has posted it, but that was posted by Payal. Question: if a developer does not undertake redevelopment for 7 years and the building is in a dilapidated condition and no time is given in the contract, how can the tenants be protected? And thank you, Subodh.
Now under the Contract Act, the time limit for seeking a relief is 3 years. I told you that time is not the essence of the contract, but still he is bound to institute a suit within a period of 3 years from the date of cause of action. Otherwise, the relief gets barred by limitation. Simple. I think it's clear.
Yes, sir. So one thing, because we have also been a student of law at one point of time,
yes,
I feel large number of people, with all respect to the audience, I'm not for a minute saying, but could you explain time is not the essence, because large number of as a young lawyer or a student, sometimes one doesn't understand what is the meaning of the time is not the essence.
I'll put it like this. The question is whether what time is the essence of the contract means. In a contract of immovable property, the parties may agree that purchase advance is paid today, the contract will be performed within a period of 6 months. Within a period of 3 months from the date of execution of the contract, the plaintiff should, the seller should produce all the documents in relation to title. After satisfying it, within 3 months thereafter, the assignment will be effected. So virtually the effect is that the time stipulated in the contract is 6 months. Now, the contract is not performed within 6 months. Suit is filed within a period of 3 years. Then the defendant sets up a case that, please see, the time agreed was 6 months. He has not performed it. Parties have not gone for that. So that after 6 months, the contract becomes unenforceable or the claim has become stale. If you reckon the date as the most crucial aspect of the term of contract, this is so that what we call it is that the time is the crux of the contract. Time is the essence of the contract. In other words, if the contract is not performed within the time of within the stipulated time, it will be considered as broken. The Supreme Court said, see, the limitation period is 3 years. In the case of an immovable property, heavens are not going to fall down if the contract is not performed within 6 months. This was the English law also. What is going to happen? What is ultimate damage that is going to happen if the contract is not? Probably they must have stipulated an outer limit for performance. That does not mean that time is the crux of the essence of the or crucial part of the contract, so that if it is not performed within the stipulated time, the contract itself will become fall down. Then that developed in the question of what is time the essence of the contract. But in the case of a movable property, we take a different view. Movable property, generally it is considered as the time is the essence of the contract. Then I will tell you how the time forms the essence of the contract. Say, for example, in the contract of immovable property, they say that we will perform the contract within 6 months. And the person who sells the property adds a clause. I am selling this property under constraints because the bank has proceeded against me. I want to repay the loan. I have undertaken to the bank to repay the money within 6 months. So the balance consideration should be paid to me within 6 months so that I can repay the bank loan and save my residential property. What does it indicate? The time was the most crucial aspect of that contract because he is selling the property. It's a distress sale. He wants to save his residential property so that the time becomes the most important element of that contract. And if it is not performed within that time limit, definitely that will cause huge loss to the seller. In such cases, we interpret that the time limit is the crux of the situation, crux of the contract. Time is the essence of the contract. When we say essence of the contract, means that is the quintessence of the contract. That's the main subject matter of the contract. We're dependent on which the validity of the contract itself will be decided. So that is how the concept of time is the essence of the contract. So we reached a conclusion that unless the terms of the contract specifically or impliedly indicate that
contract of immovable property, that particular contract should be performed within a stipulated time. Serious consequences will follow. In such case, we can presume that time is not the essence of the contract. Time is the essence of the contract. And that we have been following. Even if the contract of immovable property is not performed within the stipulated time, unless a contra intention is visible from the evident from the contract of sale, normally in case of immovable properties, it will be deemed to be not the essence of the contract. This is the difference. I think it's clear.
So, for a common man, we can say that the time would ultimately, the entire issue, if it has been something put in black and white in a contract regarding a time that it is particularly contemplated at that particular time. So according to you, the entire issue or the focus or the fulcrum would be that time, the time what you have been contemplated in that particular contract, or
Yes.
what we can say, time will become a sacrosanct for the purposes of adjudication of that case.
No. In the case of normally it will not be considered. Or a person sets up a contract. I will put it this way: if the defendant, in relation to an immovable property, sets up a contention that it was not performed within the stipulated time, the contract has fallen down. Contract stands repudiated. The courts will not accept it unless or notwithstanding the time limit prescribed, the parties give some indication that it should be treated as sacrosanct because of other reasons. That's why I said to save his property or his residential property from sale, which will happen within a stipulated time, then it has to be performed within the stipulated time. So in such cases, the court can treat the contract as time as the essence of the contract. In other cases, it will not be given that much predominance. But that was the reason given by the Supreme Court in Vidyadhanam's case. That concept of essence of the contract developed in England under the common law when the price of property remains static. Inflation was not there. So even if the stipulated time is over, that will not by itself bring the entire contract to an end, because the courts will not treat it as the essence of the contract. That's the principle. But Supreme Court said in Vidyadhanam's case, the view of the Supreme Court was that it is high time that we give way to that. Because as I told you in the case of Nirmala Anand's case, it took 36 years to conclude the litigation. Agreement was for 60,000 rupees. Just visualize what will be the consequence of what is the value of the property after 36 years when the matter is ultimately decided. So that is the impact of it. I think the concept of essence of the contract is clear.
Yes, sir. Yes. So we will be taking the last question, though questions will come on. Keep on coming. It says, is it possible to get both damages and specific performance in a single matter? The question is long,
damages?
but it says, is it possible to get both damages and specific performance in a single matter?
Yes, it can be. Damages means damages that have occurred over and above or exceptional damages which has happened. That he must be able to prove that because of the non-performance of the contract, I have sustained certain damages that can be recovered. That should be claimed in the same suit. Otherwise, he will not be permitted to.
That will be part of the res judicata.
Yes. But he should prove that it has. Otherwise, that will make a double benefit.
No, I'm saying let's assume he's not posted that issue in that case, and it will be akin to a constructive res judicata to the effect that what could have been claimed but not claimed.
Yes, it has not been claimed. Yes, under the Order 1 Rule 2 principle as well as constructive res judicata. But
Yes, sir.
as that's the reason why the section itself says that the plaintiff is entitled to ask for, a plaintiff will be given an opportunity to amend the plaint at any point of time. That's very clear. Sir. Statute itself says if the claim is not made, a plaintiff can be permitted to amend the plaint and incorporate the claim for damages.
So this is your take. One question I find it's good, so that's why I'm taking to add it last.
Yes, yes, please,
This
please.
is by Karthikeyan. Could you
Most
please
welcome. No, no,
explain
most
the?
welcome. Most welcome.
No, sir. I understand 2 hours explaining without even looking to any paper, etc. It takes a lot of toll. We know that once we talk, make submissions for 2 hours in a court, it takes hell amount of the brain and energy, and everything is sapped off. This is a personal experience. If you argue for 2 hours, and it takes a lot of amount of energy. This is it says, could you explain the amendment made in section 21 relating to claiming of compensation in addition to specific performance?
Substantially very serious amendments have not been brought in section 21. Very not some very important amendment has not been brought in section 21. Either or in addition to or in substitution. That's the only substituted by that section. Either in addition to, that comes in clause 1 of section 21. Originally, it was in a suit for specific performance of a contract. The plaintiff may also claim compensation for its breach, either in addition to or substitution of it. And the substitution part now goes. Now it is only in addition to. Or he could have, earlier it could have been as an alternate. Now it need not be alternate, it can also be in addition to. Both can be claimed. So definitely, the new amendments are always in favor of the plaintiffs, or normally heavily loaded in favor of the plaintiff. Yes. Anything else?
The company received a lease land from a development authority. Contract repudiated as time to start project has lapsed. Can we claim for the reinstate? Can we go for the reinstatement of the lease? What are your insights?
What is that? Lease?
Can we go for the reinstatement of the lease?
Contract for lease.
Yes, I will read that. It says a company received a leasehold land from a development authority. Contract repudiated as time to start project has lapsed. Can we go for the reinstatement of the lease? What is your take?
No. Because lease, by the very nature of it, is it not something which is determinable at the option of the parties? That's one aspect of it.
Right, sir.
Secondly,
So
if delay, it was for a long period lease, and it has not affected the plaintiff, the person who takes it on lease. It cannot be repudiated unless the period expires. The only difference can be that when that time limit is the most crucial aspect of it. That can be the only possible way. Is it clear?
Yes, sir. So thank you for the insights. The subtle differences between the words, the entire gamut of the specific performance and the effect of the amendments couldn't have been brought in a much better way. The way you have put it across, the subtle differences between readiness and willingness, the practical insights along with the case law, the way people have posted on the chat box as well as on the Facebook, it only shows that people are actually enriched by that. And it in fact gives us the satisfaction that when people actually receive well, and I will not only say the participants, it gives us, at least to myself also, certain issues which keep on bothering in the mind of a lawyer as a lawyer. being a moderator is something else, but being a lawyer also, one wants to learn the things. And there couldn't be a better way to have a entire scheme of affairs in a bird-eye view. So we are all thankful on behalf of Beyond Law CLC, the way you have put the things across. Definitely, after the insights you have been given, we are all highly grateful to you. The way you have
Thank you, Mr. Vikas, for
you have
giving me
given,
this opportunity.
you have given us the clear explanations to all the things, which
Thank you.
invariably are to be utilized by a lawyer or a professional or a student or a professor if he has to
Yes.
teach. There couldn't be a better way. We will connect you for some other webinar, the way you have put the things across.
Sure. Most welcome, Mr.
All very grateful to you. And thank you. The comments are still pouring on, saying a word of appreciation in your word. If somebody is asking,
Okay.
Monday upload.
Thank you very much. Thank you all.
Thank you, sir.
For giving me a
those who
patient
couldn't
hearing.
connect with us, they can always watch this webinar. We will be posting on the YouTube channel, and it is also right now also uploaded at the same time since we were live on the Facebook. You can also watch that.
Okay,
Stay connected with us. Tomorrow we have Mr. BT Call, the former chairman of the Delhi Judicial Academy, on the insights of the labor laws and the perspectives which have changed. So do stay connected with us. Everyone stay safe, stay blessed, and thank you, sir, for all the insights.
Thank you very much. Thank you, everybody.
Thank you.
And Mr. Vikas for giving me this opportunity once again. Thank you.
So, that only shows your humbleness. We are, in fact, to have a speaker of knowledge and who is an erudite speaker. It only speaks well. Thank you, sir. Namaskar, everybody. Stay safe, stay blessed. Thank you.